I greet you all. Can you all hear me?
Yes, ma'am. Here.
Yeah. Well,
Yes, ma'am.
I welcome you all
Yes,
here.
we hear you.
Very hearty welcome to all attendees and to our respected keynote speaker, Dr. Mukesh Bansalji, who has been into kind of an industrial world, being a company secretary since 1982. I'll read his biodata later on because today is our inaugural day, so a lot of preparation had to be done. So, meanwhile, sir would be addressing to all of us. But, sir, you just hold on for a minute. Let me just start with certain things that has to be brought into the limelight. That why are we holding this event? Who is the main spirit? And what is the purpose of this event? And how come suddenly this kind of idea cropped up in our mind that we should hold this kind of program? So my first question is like, why are we celebrating this kind of events one after the other in Bhupal Nobles University? So Bhopal Nobles University is a very recognized private state university under the State Legislative Act 2015, and it has been given recognition from University Grants Commission. Also, it has University Grants Commission has enabled it to award degrees and certificates in diploma, and that's a very commendable part. Within 6 years, it has been able to cover up to this stage of being in the academic world with some kind of recognition. Another important aspect of this celebration or holding this event is that Bhopal Noble Sansthan, this you may say a big tree, a burger tree, we may say, it was founded by late His Highness, the King Maharana Bhopal Singh Ji in 1923. And Bhopal Noble Sansthan is an offshoot of that kind of dream. In 1923, it had its origin, inception, and slowly and gradually it spread its wings and titled it itself as Bhopal Noble Sansthan. And under the chief patron of late His Highness, the King of Mewar, Maharana Bhupal Singh Ji, he became the pioneer of education in Udaipur, Rajasthan. It started as a small pre-primary school and has grown into a complete educational facility with many of the increased number of academic educational units. And day by day, they started being recognized by the government regulated bodies for the awards of degrees and certificates. Maharana Bhupal Singh Ji was the proponent of modernization and a great man with far reaching thinking towards all-round integrated harmonious development of remote rural tribal area of southwest Rajasthan comprising of Udaipur, Banswara, Khelwara, Dungarpur, Rajsamand, etc. So this kind of dream has taken its big wings and had spread its you may say popularity not only in national you may say scenario, but it also crossing borders, and it has come across popularly and acclaiming itself in the international platform also. So this year actually is celebrating the centenary year of crossing the 100 years of its foundation. Now come to our webinar, or you may say today's theme. Basically, we have been in association with one of the international institute for advanced legal sciences, and it is maybe you may say a branch of one of the big vision that was set by some other you may say popularly acclaimed jurist, and its origin also lies in the name of a Roman jurist, Gaius, who existed in the period of Common Era between 130 to 180, and his writings became so canonized that he wrote a commentary on the law of the 12 tables, and this treatise was actually on the edicts of Roman magistrates and several other works. His writings show an interest in legal history, Greek philosophy, and the classification of laws. So today we are actually all of us across the world, whosoever contributing in this symposium, paying tribute to two great luminaries, guys, the Roman jurist and the Maharana, late His Highness of Mewar, Bhupal Singh Ji. Of course, the contemporary world is enjoying the fruits of the hard work these luminaries left for us, and we as survivors are carrying that vision forward. Now, again, I come to the purpose of, or you may say the topic of this conference or symposium. I would credit my colleague, Miss Kiran Chauhan. She is an assistant professor from the Faculty of Law, Bhupal Nobles University. When I discussed with her my vision, she said, ma'am, the most popularly taught book in the Faculty of Law at the initial level is of tort, the law of tort. So I said that one of my mentor and very great friend, Professor Salvatore Tolone Azariti, from the Universidad de Buenos Aires, has written many papers on this kind of law, and he's a great expert in civil law and private law. So Miss Kiran Chauhan, immediately she gave me an idea and the title of this whole symposium. And the title of this symposium is The Changing Concept of Liability and Its Variables. So I thank my colleague, Ms. Kiran Chauhan. You all can see her on the screen. She's visible here. She would take the lead to start with her address, and then next our deliberation would be done by Dr. Mukesh Bansal sir, and then slowly and gradually our chairperson, Honorable Professor Sharad Srivastav, formerly the Dean of Faculty of Law of Mohanlal Sukhada University and the head of the English Department of University College of Social Science and Humanities, he would also join. And we would be also expecting at the same time our panelist and the co-host and the associate, Professor Salvatore Tolone Azariti. So I begin with Ms. Kiran Chauhan and look forward to a very healthy discussion and opinion on the theme of the symposium. Ms. Kiran Chauhan.
Thank you so much, ma'am. I'm audible to all of you?
Yes.
Okay.
Yes, madam.
Well, it's being an honor that we have been joined with Jashri ma'am, and she has started the initiative to this event, and she has given us this opportunity to being a part of it, because we are just the learner. We are on the stage of learning, and we are learning phase from in collaboration with Jashri ma'am. So first of all, I would like to welcome all of you, Mukesh Bansal sir, and recently Shiv Singh ji sir has also joined it. Welcome, sir. Today we are just I would say we are just discussing on the concept of liability, and as I have seen, as my PhD's topic is also related to the environment, so I have started the topic with the liability in context of environmental law. So I will try to make whatever I have learned from it and whatever I have compiled the things, I hope it would enhance your knowledge in it. And if I would not be able to cope up with the subject, please help me out. May I able to join it? I will share now. Is it visible to all of you?
Yes, madam.
Yes, ma'am. Yes.
Yes, ma'am.
Okay.
Yes, ma'am.
So my topic is various liabilities in environmental law. So before moving further, first of all, we have to understand what is liability. In the context of simple terms, liability is considered as the state of being legally responsible for the activities that cause harmful damage to the environment. It is a word which is viewed from the two different perspectives, accounting and legal perspective. When we would say कि liability in accounting, it means the financial responsibility of a business or organization. And when we are also discussing the liability in the legal perspective, then it means a liability is a legally enforceable obligation, whether it is voluntarily entered into as contractual obligation or is imposed unilaterally, such as the liability to pay taxes. The law both establish liabilities and determines who is responsible for discharging them. So the environment liability is the term which is used for the process by which the responsibility of cost of damaging the environment is laid on the person who damages the environment. So liability for environmental harm is designed to compensate the affected parties with a particular focus on restoring or replacing injured resources or providing compensation for lost values. So by increasing the cost for those who are harming the environment, liability provisions can serve an important deterrent role, promoting compliances with the laws and regulation. In the next, we are discussing the types of environmental liabilities. The typical environmental liabilities a company may incur include compliance obligations, fines, penalties, remediation, obligation, rehabilitation, obligation, and compensation obligations. Environmental liability is an instrument of environmental protection for the prevention of and compensation for environmental harm. It promotes the personal responsibility of the economic players. Properly, it constitutes the environmental liability. It law creates economic incentives to prevent the occurrence of harm, paving the way for the payment by the polluter of compensation for any harm that occurs. The legislature has also created environmental liability legislations under both public and civil laws. In terms of civil laws, this is a matter of compensation for harm to life, limb, health, or property of individuals who fall victim to such harm mediated by environmental media as a result of the conduct of other individuals. As we are moving in the modern context, modern technology, as we are moving towards the industrialization, then it is due to the industrialization, it has also created in the problems, we would say, in the environmental realm. While the dependence of modern economies on companies can hardly be questioned, it is an established fact that companies are mostly considered as responsible for damaging the environment by depleting natural resources. Consequently, the legislator has made attempts to ensure that companies should the environment does not get adversely affected. There's a specific legislative enactment is also made by the government in order to protect the environment. That is an act that we students have also discussed earlier, the Environment Protection Act 1986. The legislator has enacted the Protection Act 1986 under the Article 253 of the Indian Constitution after the Bhopal gas tragedy. And this tragedy we will discuss later. What is it about? And this was done to implement the decision that were taken in the United Nations Conference on the Human Environment 1972 regarding protection and betterment of the environment and to suggest ways to prevent hazards to all living organisms. The purpose of this enactment, this legislator, was it is considered an umbrella legislation and it enables laws that provide a framework for the government to coordinate activities between central state authorities established through various ancillary provisions. And this act also prohibits the companies from emitting any environmental pollutant more than the standard that have been prescribed in the act. Consequently, the central government has also framed the Environment Protection Rules of 1986 that lay down various standards that the industries are expected to follow. This include emissions standard, noise standards, and other standards. And this act has conferred power upon state and central pollution control board to enforce these standards. In this act, we have also discussed about the corporate social responsibility, the environmental aspect of CSR. It is a duty of corporate to cover the environmental effect of the company's product operations and facilities. It removes waste, emissions, and it increases the productivity and efficiency of its resources, and it decreases the practices that may adversely affect the enjoyment of resources by future generations. When while the corporate social responsibility guidelines are there, they had provide for guidelines for several core elements. For it, respect for the environment, urge the company to prevent pollution, recycle waste, manage natural resources, and adopt environmental friendly technology. We are also discussing with this environmental impact assessment is also there. Since every human activity affects the environment, it is important to synchronize the activities which are imperative for development with the ever increasing environmental concern. Environmental impact assessment is a tool that ensures the same. It began in India in the late 1970s, and it aimed to detect the environmental problem that are likely arise out of a project that is proposed and try to settle those problems in the initial stage. So by preventing future liabilities and expensive alteration in project designs. Other legislative enactments are also there. That is the Water Prevention and Control of Pollution Act 1974. This act prohibits entry of any poisonous, noxious, or polluting matter into any stream, well, or on land for disposable determined in accordance with such standards as laid down by the state board, thereby making the company responsible for whatever they are discharging in water bodies. Another act is also made up, the Air Prevention and Control of Pollution Act 1981. This act provides that a person operating an industrial plant in any air pollution control area shall not discharge or cause or permit the discharge of the emission of any air pollutant exceeding the standard laid down by state board. The environmental management system, it is the organization structures, responsibilities, practices, procedures, processes, and the resources for determining and implementing environmental policy. This framework helps the companies in achieving the environmental goals. So the environmental management system required the organization to identify its significance aspect and their impact, and in turn, it developed policies according to the legal requirement. According to the National Voluntary Guidelines on Social, Environmental, and Economic Responsibilities of Business 2011, the Ministry of Corporate Affairs incorporated the advice given by stakeholders and released a new set of CSR guidelines for corporation. These guidelines encourage business to be accountable for the environmental impact of their operation and products and to constantly strive to make the environment friendly. With regard to this, there are certain case laws also there. In one of the case of Uttar Pradesh Pollution Control Board versus Mohan Mackin Limited, in this case, the matter was related to the discharge of trade affluents by an industrial unit in a river Gomti. And the directors of that company were accused of an offense under Section 43 of Water Prevention and Control of Pollution Act 1974. So the Supreme Court has held in this case that lapse of a long period of time cannot be the reason enough to absolve the directors from the trial. In the case of Mahmood Ali versus State of Bihar, it was also held in this case that under Section 319 of CRPC 1973, a criminal court can add a person against whom evidence comes forth during the trial showing his involvement in the offense, not being the accused before it, and as an accused and try him along with those that are being tried. In the case of Haryana State Board versus Jai Bharat Woolen Finishing Work, in this case, the court has held that the section 47 of the Water Prevention Control Act that relates to the offences by the companies, which include a partnership firm, it lays down that where an offence under the act is committed by any company, every person who at the time that offence was committed was in charge of or was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. So it can be concluded from this that the growth of environmental law has greatly impacted corporate governance in the present day, since companies are now expected to live up to the standard that have been laid down by these legislations. The legislation have put a check on the companies and made it mandatory for them to abide by certain guidelines, which is a need of the hour, considering the importance of both industrialization and preservation of environment. The next liability we are discussing in the context of environmental law is the criminal liability. Environmental crimes are widely recognized as among some of the most profitable form of transnational criminal activities. Environmental crimes are on a rise, so it should be the effort in preventing them. Even functional criminal law, it aims to deter and generally prevent such activities. In case of India, our environmental laws mostly focus on the areas which involve air pollution, quality, water pollution, sustainable development, waste management, and safety in dumping, dealing with the chemical elements. However, their implementation entail far more complex issues, having an interplay of social, political, and economic factors in addressing the serious environmental repercussion. All these environmental rights and principles have been behind the development of environmental and judicial adjudication in the country. The existing framework is invoked in imparting the role of various public and private enterprises, statutory and common law applications and performances. When we are discussing about the types of environmental crimes, these crimes are considered as under the organized criminal activities all around the world. Environmental crime are also known as green collar crimes, which constitute the fourth largest crime in the list. And they are crimes which are follows as poaching, illegal trade of wildlife, trade of unregistered illegal product for financial and material gains, for example, trade of timber, ivory, rhino horns, sandalwood, unreported fishing, illegal logging. Other than also non-exhausting list of environmental crime is much more than. It includes littering, waste disposal, dumping into water bodies, wetland destructions, improper handling of pesticides, improper removal of asbestos, smuggling chemicals, etc., etc. When we are talking of under the context of Indian Constitution and judicial intervention, as in the concept of the fundamental rights, fundamental duties, and directive principles of state policy of the Indian Constitution, India has worked towards its national commitment to furthering the cause of environmental protection. These particular articles that I have shown it, they have been a guiding force for the country to ensure a wholesome environment for its people. All such enactment, legislation, and their enforcement are as a result of public interest litigation, which is based on the judicially settled principle under Article 21 of the Indian Constitution, which recognize the fundamental substantive right to healthy and pollution-free environment. Further, according to as per 42nd Amendment, the word environment in the Indian Constitution has also added with Article 48A of Directive Principle of State Policy and Article 51A under Fundamental Duties. Next, we are discussing what are the prominent principles of environmental law which are guided for the Indian courts. Indian courts are guided with these principles while dealing with the cases of environmental law. First of all, thing is there, sustainable development. This concept aim in fulfilling the current needs of the people without diminishing the access of the future generation to similar resources. Next principle is polluter pay principle. The name itself describes that person who is creating the pollution will pay. It holds the polluter liable for the damage that is caused to the environment. The polluter not has only to compensate the victim of the pollution, but also has to compensate for restoring the environmental degradation that has already been caused. In next principle, precautionary principle, it name suggests that it promote the implementation of preventive measures in situation that can cause serious threat or irreversible damage despite the absence of any scientific certainty. It can be helpful in arriving at environmentally favorable judicial outcomes, but it does not well for the development of a clearer line of jurisprudence. Next principle is public trust doctrine. This principle is also applied in various environmental law cases. In the case of MC Mehta versus Kamalnath and others, 1996 case was there. It promotes that the idea that no single person own the natural resources. No single person own the natural resources. It is upon the government and the regulatory authorities to act as trustee and hold the resources for free use of these resources by the general public. In the context of Indian Penal Code 1860, there are certain few penal provisions were also there as per section 268 that classify environmental crime as a public nuisance, and according to the section 290 of Indian Penal Code, it penalizes the offense causing a public nuisance with a fine which extend up to rupees 200. Thus, those who act or omit causing injury to others by environmental pollution, then they can be subjected to prosecution. Section 277 is also applied for preventing water pollution and impose punishment up to 3 months or certain fine. And these certain section 426, 430, 431 and 432 of IPC also penalize any pollution caused by mischief. When we are discussing about the Criminal Procedure Code 1973, under the Indian Criminal Procedure Code, Chapter 10, Maintenance of Public Order and Tranquility, it also provides preventive and mitigating measures for public nuisance that cases pertaining to water, air, soil, and unsanitary, unhygienic conditions. Section 133 of CRPC, it provides for the remedy to the environment pollution in general by empowering a district magistrate and SDM, subdivisional magistrate, to stop the nuisance. Any order made under this provision shall not be questioned in any civil court. So we have discussed the criminal liability. After that, there is certain tortious liability because without discussing the tort in environmental law, you would say the subject will not complete. So we have to discuss the tortious liability in context of environmental law. Tort law and environment harms due to pollution are interrelated. They are so closely that even today, in spite of huge legal development, majority of all the cases related to environmental harm come under these ambit of four types of tort, which are trespass, nuisance, strict liability, and negligence. In India, tort, if we will discuss about the tort law, that is uncodified law, it come into effect with the aid of Article 372 of Indian Constitution subclause first, which state that all the laws which were in force before the independence until repealed or replaced with a new legislation by a competent authority will not lose their existence and will remain in force within the territory of India. In addition, it must be keep in mind that the state, both central and state government, can be sued by its name under Article 300 of Indian Constitution. The present Indian legal system is formulated on what we would say is the Anglo-Indian judicial system, which in 1772 was adopted by Warren Hastings through judicial plans and become the base for later legal development. Similarly, judges were also advised to act on the ideals of equity, justice, and good conscience in the absence of proper legislation or where there are loopholes in them. It was believed that these ideas were able to fill the gaps between the laws. Later, after codification of a number of laws, common law was still dominating Indian laws. When we discuss about the role of Indian judiciary in extending torture liability in cases of environmental harms, in India, judicial activism and increase in environmental tort litigation, which started with the Bhopal gas leak accident, that is the MC Mehta versus Union of India. In this, due to the leakage of poisonous MIC, methyl isocyanate gas, millions of people suffered from a health problem. And over 2,500 people, would be more than it, died with the immediate poisonous effect of the gas. With such massive harm to the environment and human life, the doctrine of absolute liability began to evolve in India. And finally, it is adopted in the MC Mehta versus the Union of India case. The Bhopal gas tragedy was an eye-opening accident for the people with the different backgrounds, including state, central government, media person, litigators, even industrial management, that the tragic accident, a new feature should be introduced in the Indian judicial system. And when the person started linking tort with the environment, there was a growth in the concept of exemplary damages. The new doctrine of absolute liability, which developed after Bhopal gas tragedy, is different from the English concept of strict liability that is come into effect with certain exceptions, because when we will discuss about the strict liability, there are certain exceptions to it. But in the case of absolute liability, there is no exception at all. So in this case, MC Mehta versus Union of India, the court has also gave the deep pocket theory of compensation. And the Justice P. N. Bhagwati has also observed that larger the enterprise or industry will be, larger will be the amount of compensation that will be paid if there is an inherently hazardous or dangerous activity is carried out. And it is given a wide interpretation of Article 32, that is issuing writ, was formulated with the introduction of new rights and remedy. In the next case of Consumer Education and Research Center versus Union of India, in this case, the principle of absolute liability was not revisited, but the court introduced new liabilities and stated that the compensation given in case of damage is not limited to the worker with the visible symptoms of the disease during the course of their employment, but it also extends to those workers who suffer from any disease after their retirement. The court also showed that in case of violation of fundamental right, the direction under Article 32 are not limited to the state. It can be extended to other persons and company acting under any statutory power or license. In the case of Bandhua Mukti Morcha versus Union of India, it was also a landmark judgment due to the fact that in this the Honorable Supreme Court has stated that the power of court under Article 32, which deals with the right to constitutional remedies, is not limited only with the issuing directions, guidelines, or writs to enforce fundamental right, but it puts an obligation on the court to check whether fundamental rights of the people are protected or not. In the case of Indian Council for Enviro Legal Action versus Union of India, in this case, the court has observed that the law needs to be accommodate itself with the changing needs of the society, especially in a country like India, where economic and social transformation is a challenge due to rapid industrialization. And this case only, the principle of polluter pay principle has adopted. Next, we are discussing about the corporate liability. As we had discussed the criminal liability, tortious liability, now we are moving further to the corporate liability. We would say the typical form of environmental law is to impose particular administrative requirements on industry describing the allowable amounts and quality of polluting emissions and to punish violators of these requirements as environmental crime. India's environmental laws grow out of another international, you could say, compliance framework, that is Stockholm Conference on Human Environment in June 1972. When the Indian first environmental legislation that is the Water Act of 1974, was enacted. It was similar to the already existing general body of law. This act was just a supplement to the licensing based legislation. Only when the judiciary began to interpret environmental laws more strictly and formulated essential principles for environmental betterment, then only environmental law in India truly come into their own. The country's apex court emerged as the savior of the country's natural environment. When we are discussing about the offenses by company, when the company commit an offense, what would happen? When a particular company has committed any offense under Section 40 of the Air Act 1981, everyone who was directly in charge of or responsible to the company for the conduct of the company's business at the time the offense was committed, as well as the company, is deemed guilty of the offense and is liable to be prosecuted and punished accordingly. If he established that the offense was committed without his knowledge or that he exerted all necessary diligence to prevent the conduct of such offense, nothing in this section shall render him responsible for any punishment stipulated in this act. Where an offense under this act is committed with the consent or attributable to any neglect on his part of any director, manager, secretary, or any other officer of the company, then such director, manager, secretary shall be deemed guilty of that offense. He shall be liable to be prosecuted. This section, I would say, is also content exemplify an ad hoc approach to enforcing criminal liabilities on corporation. We can see from these provisions that the offense by company provide an opportunity for the corporate and individual culpability for officers in default. There is no unique framework for dealing with the environmental damages caused by body corporate, but this act is ineffective and severely limit the applicability of the principle outlined in these acts. When we would discuss how the companies is polluting the environment, there are many ways that the company has polluting the environment. In today's political atmosphere, environmental protection is a controversial issue, with many people believing that pollution protection is unnecessary. Environmental contamination, on the other hand, has a direct impact on human health, which can be quite significant and even fatal. Companies and corporations are far too often directly responsible for environmental contamination, but is causing serious and long-term illness and also there. There are certain, you could say, certain healthful impacts of the companies. It could be dust hazards, dust exposure, particularly silica dust can cause fatal lung disease, silicose, lung cancer, variety of other respiratory disorders, asthma, and various on.
Kiran,
And yes, ma'am.
Could you please now shorten, because we are you're exceeding 10 minutes more. You've
Okay,
already
ma'am.
exceeded.
Okay, ma'am. Now I'm just coming to the conclusion.
Because then Professor Dr. Mukesh Bansal has a long to deliver.
Yes, yes, ma'am. I'm just coming with the conclusion. I would now conclude my paper that the person is made liable only when he is at fault. But the principle governing these two rules is that a person can be made liable even without his fault. That is the principle of no fault liability. Under these rules, the liable person may not have done the act, but he will still be the responsible for the damage caused due to the act. In cases of strict liability, there are some exceptions where the defendant would not be made liable, but in the case of absolute liability, no exceptions are provided to the defendant. The defendant will be made liable under strict liability. So at the end, I am concluding with, given the global risk of large environmental deterrent, it is high time for judicial activism, because even while a government is attempting to be as progressive as possible, it is still lagging in filling up the gaps in current legislation. It is also worth noting that a Honorable Supreme Court has pointed out that environment and development are two sides of the same coin. If one is changed, the other is bound to be affected as well. I will end my paper with the quote of Mahatma Gandhi: "Earth provides enough to satisfy every man's need, but not every man's greed." Thank you all.
Thank you, Ms. Kiran. It's a wonderful part on your deliverance, that you have given us a lot of potentialities about environmental liability that has to be constitutionally checked and into a process of more further recorrections. So I now invite next speaker of our symposium, Dr. Mukesh Bansal Saab. Bansal Saab, you continue with your address, and then later on when our Professor Salvatore, actually he joined in between, and I thought not to welcome in between because their time is quite precious. So please continue with your discourse.
Okay, good evening to all of you. And Dr. Jashri, thank you for inviting me into this symposium and with a very noble institute of law established by a special act. And I feel that all those who are into the meeting having their own precious time given us this time to talk to us. And welcome Mr. Ajariti, who is there joined is right now, and with me as a spokesperson from the Government of India Ministry of Corporate Affairs. This SEBI has given this accreditation to me for allowing us to talk to on Global Money Week. In this is, I'll share my presentation with all of you.
Meanwhile, I welcome our professor, mentor, dear Dr. Salvatore Azzariti, sir. Sir, you're welcome. Can you hear us?
Thanks so much, Professor, and good afternoon, good night to everybody.
I thought the class should go on, so I allowed you to enter late so that you may feel that the class is going well in a disciplined way.
I experienced the troubles with Google Meet, Doctor. Next time.
So what? Students are attending.
Yeah, we should have a lecture about Google and law.
Yeah. So may I introduce Dr. Bansal meanwhile? He's a fellow member of the Institute of Company Secretaries of India since 1982, and he's life member on the alumni list of IIM Ahmedabad, life member list of ASCI Hyderabad. He's a regular faculty at different management institutions of repute, and also faculty at personal training colleges of Northwestern Railways, schools and colleges. And his professionally career has started in management as a trainee in Birla Group in 1980, and then continuously in corporate industries or firms. He continued his services till 1996. Then he switched over to educational units, for example, NITT, and then Jodhpur chapter of ICSI, and even medical colleges, nursing colleges. So here he has been continuously delivering his discourse with regard to financial literacy, investor awareness, role of regulators, spearheading much needed way in different organizations. So let's hear to Dr. Mukesh Bansal how he is going to draw light on the changing concept of liability and its variables.
Thank you, ma'am. Thank you. Thanks for a nice introduction. Yeah, so good evening to all and welcome to this symposium. I, CS Mukesh Bansal, the founder chairman of Jodhpur Institute of Company Secretaries of India and a resource person from BSc IPF. I am there to draw light on role of regulators, young investors and professionals to learn under the Global Money Week 2022 special. In this Organization for Economic Cooperation Development, that is OECD, an international organization, Securities and Exchange Board of India, Reserve Bank of India, Insurance Regulatory Development Authority of India, Pension Fund Regulatory Development Authority of India, and National Center for Finance Education both have come together and give details to all. So in that context, I am grateful to the organizers and more particularly Professor Jayashree to have allowed me to come to you all with this presentation. Talking about something about BSE, that is founded in 1875 with the building you can see is Bombay Share Brokers meeting place, and in 2022 you can see that shape of the building and say 147 years of tradition, trust and transparency my organization BSE has worked for. And this is the oldest stock exchange of Asia. And in sixth part of the nanosecond, the transaction takes place. 1875, we came into existence as an official organization, the Native Share and Stock Brokers Association. And 1956, with the advent of the Companies Act 1956, the stock exchange became the first stock exchange to be recognized by the Indian government under the SCRA, Securities Contract and Regulation Act. This stock exchange switched to electronic trading system in 1995, and it was perhaps the first time we got into this. On 19th August 2005, it became corporate entity. So, talking about this stock exchange, that the organization BSE has been instrumental in developing India's capital market. We all know the capital market is the nerve of the economy, and rise and fall gives an indication of the health and deteriorating health of the economy. So for electronic trading system, now it is better known and the fastest exchange in the world, having a speed of 6 microseconds. The moment we just want to say something, many of the transactions have happened on the stock exchange. So debt instruments, derivatives, mutual funds, equities, currencies, all we deal into, and important capital market trading services as risk management, clearing, settlement, and investor education is the part of BSE. We take care of the secondary market also, like investor exchange with each other rather than with the issuing entity. Tough, massive series of independent yet interconnected trades. The secondary market derives the price of securities toward their actual values. Yes, more than 5,500 companies are listed on our stock exchange, and they provide liquidity to the investor also and liquidity to the owners also, and much inflow in the market with the exchanges. What are the products? Yes, just a little highlight on this. Equities, we provide you. Debt instruments, we give you. We provide you the equity derivatives. Yes, BSE has the platform for a startup. Lot of legal consequences are there, and lot of legal professionals, they find good career opportunities in giving the advices to startups also. And currency derivatives, yes, USC platform we provide you. Funds and exchange traded funds, that is the BSE Star MF platform we are giving you. And BSE SME platform is very good platform where lot of small and medium scale enterprises, they have come into existence, and they are in fact shown their confidence in the market and grown. And insurance part, with the world fame IBIX, BSE has come into, and commodity derivatives are the part of this. And looking into the trading part, if somebody wants to trade on the stock exchange, they require 4 things. One is the trading account with any SEBI registered recognized broker. They need to open the broker trading account. One demat account with any of the depository participant like NSDL or CDSL. They need to open. A bank account is required because nothing can happen into the cash nowadays. And permanent account number issued by the Government of India, Ministry of Finance, Department of Income Tax. So if these 4 things are there, you are welcome to the capital market. So talking about the much needed regulator, yes, and much required and much recognized, reputed this regulator, that is Securities and Exchange Board of India, Bharatiya Pratibhuti Evam Nirgam Board. So this is the regulator which was established on 4th April 1992. We call it by the special act, the SEBI Act 1992. What was the background? Yeah, we all know the capital market turbulence at the time 90s. Harshad Mehta time, lot many scams took place, a lot many activities happened, which totally shaken the investors, and not only investors but the executive, not only executive but the entire system and the government itself. So the taking the lead from that, OECD and all these things, SEBI Act came into the existence, and with the special act of the Parliament, the SEBI Act 1992 was enacted. Yes, much power were given to the SEBI under the Depository Act 1956. The Securities Contract Regulation Act 1956 also provided teeth to the SEBI, and the latest, the Companies Act 2013, provided much needed powers to the Securities and Exchange Board of India. So, getting into the action, anything related to regulation of capital market, whether it is mutual fund, whether it is share market, whether it is any financial instrument coming into the market for the investors and for the share market, SEBI is the regulator which gives its consents or declines or made regulations for all these activities to regulate in the better way. हर इन्वेस्टर की ताकत के रूप में अगर हम जानते हैं तो this is SEBI, Securities and Investor, strength for every investor, and more so for a smaller this small investor. Nowadays, SEBI has come into way in a very, very active way. There are 4 regulators Government of India has enacted for us. Yes, these 4 regulators are giving us the strength. First, SEBI, Securities and Exchange Board of India, through its website www.sebi.gov.in. Any consultation, any complaint, any suggestions can be given to this. And SEBI regulates the capital market, the stock market, and the financial markets. Wide power, as I earlier discussed, has been given to the SEBI to make it more compatible and more approachable to the investing public. And after the turbulence of 1992, after the decline in 2009, after the turbulence in the market in 2017 and 2019, forget about this COVID phenomena, SEBI has drawn definite and very good powers with the from the Government of India and looking into this. And SEBI's grievances portal is open to all of us as an investor 24/7 by 365 days. Yes, you can go on to this scores portal that is given on the right side of the SEBI website, where any investor can approach and any company through SEBI giving its this approach to the grievances. The second regulator which has come into this existence is the Pension Fund Regulatory Development Authority of India, that is PFRDAI. In the year 2008, this PFRDA came into existence, and this governs the ambit of any pension fund, any provident fund, and new pension scheme, that is NPS we call about. So any grievances, any suggestions, any regulation, or any thing which governs the areas of this pension fund are regulated by PFRDA. Similarly, this PFRDA authorities are connected to all of us 24/7 by 365 days through their grievances portal or this on the website of the PFRDA. Another regulator we have in the sense of regulating the much needed power of insurance companies, that is Insurance Regulatory Development Authority of India. Yes, IRDAI draws power from the government, and under the government provisions and the special act, this authority has been formulated, and anything related to insurance, anything related to the companies and having business into insurance, anything related to policies, provisions, and anything related to premiums. Yes, IRDAI is the authority who can discuss about these things. And fourth regulator, which is very powerful, is the Reserve Bank of India. So any monetary policies, anything which is connected with the banking system or financial system, regulator is the Reserve Bank of India. So all these 4 regulators are very powerful, and we the legal professionals have very good potential of having our career opportunities with the regulators. If you go onto the career side of these regulators, you'll find a lot of vacancies for the law professionals also, because we the law professionals are compatible, we the law professionals are exposed, we the law professionals are there to help all the stakeholders of the companies or the public or the government or investing public in general at large. So we have this good connect with the regulators. I would like to draw very good opportunities for us that investor grievances redressal mechanism that is there available on the BSE platform also. So under investor grievances redressal mechanism for complaint against companies and brokers and sub-brokers, anybody can raise the complaint about. But before raising any complaint or claim, an investor should ensure that should not related to loan transaction. If anything is related to loan transactions, this is not the platform. Should be against broker of any Bombay Stock Exchange, should not be against unregistered share sub broker. That is, we mean to say any grey market transactions are not taken care of, and should not be for transaction not executed on Bombay Stock Exchange, should not be without supporting documents. So we always say that whenever you have entered into any transaction at the stock exchange, do ensure that you have read the documents, you sign the document, you keep a copy of the document, and then only you enter into transaction. And these are the guidelines given by SEBI to every broker, every investing agency, that they will complete these transactions before getting into execution. So before lodging the complaint, we the investor should know that we have all these things with us. What is the mechanism? Redressal of investor grievances through SEBI complaint redressal system. I told you scores platform. Yeah, that is on the right side of the SEBI, and every investor can try this, and any stakeholder can get into scores. Handling of complaints by the stock exchange, action for failure to redress investor complaints, and action after redressal of investor grievances by the company, that is taken care by the SEBI authorities. And believe me, young friends, that it is an automatic process. The moment you register a complaint against any stakeholder or any intermediary, you get a complaint number, you get the process done, and after that the SEBI authorities, they process and they follow up the matter with the companies or the intermediaries. And you can check your part of, and you can check your part of progress on the scores portal any day by taking the complaint number system that is given to you at the time of lodging the complaint. Arbitration is also there. Why I'm taking this judicial process and all? Because there provides a career opportunities for all of us and a legal field for all of us. That is a arbitration at PSE is quasi judicial mechanism. Yes, matter decided by the arbitrator cannot be taken to the court. Arbitration award by the arbitrator cannot be enforced, can be enforced under the Civil Procedure Code 1908 as if it were decree of a court. So that is the power has been given to the arbitrators. Exchange provides administrative and secretarial assistance to the arbitrators. Yes, that is the duty of the uh, uh, BSE, that to provide administrative and secretarial assistance to the arbitrators. And investor having claim below 10 lakhs do not have to pay any arbitration fees. See, that is the Kiran ma'am was referring to the CSR. Okay, then as part of the CSR or as part of the process and help to the small investors, investors having claim below 10 lakhs do not have to pay any arbitration fees. But who can be the arbitration committee? Arbitration committee consists of retired high court judges and professionals such as solicitor, chartered accountants, company secretary, etc., and person having knowledge of capital market. So all of us can get into the arbitration committee and have a very good say on this. 100% of the committee consists of outside experts who are not brokers of the exchange, so as to keep the privy or so as to not get any way prejudiced by any activity of the action of the persons involved in the litigation. And committee constituted by every year and approved by the SEBI. SEBI has given the power to has the power to appoint the committee, and every year it is approved by the SEBI. On the scores portal, that is SEBI Complaint Redressal System, launched on 8 June 2011, investor-friendly, centralized web-based complaint redressal system, and you can fill the complaint on www.scores.gov.in and view it, the progress of the complaint online. The mobile app is available on both iOS and Android platforms. Complaint can be filed against like listed companies, stock exchanges, stock brokers, depository participants, registrar and transfer agents, share transfer agents, mutual fund, portfolio managers, debenture trustees, merchant bankers, and underwriters. So, in all, if you see in Toto, everybody who is involved as a channel into the stock market operations or financial market operation are liable and responsible to the SEBI, and anything which pertains or anything which pinches the investor or end of the day anybody in the stakeholders grievances can be solved through a course, that is SEBI compliant redressal system. This is one part of the legality of the system, and another, just since it is a global money week which we are celebrating across the world and in India with the SEBI and all four regulators, just to have a change of subject somewhere, like why one should invest. Yes, why one should invest is to put your ideal resources onto the job, generate a specified sum of money, and make future from the uncertain, make provision for the uncertain future. And for this, all gentlemen and ladies, we need knowledge. So any financial planning we need to do for our meeting our future requirements or saving potentials, yes, one should have the capability to invest also. What is the index and its movements? There are two types of index prevalent in the market. One is Sensex, that consists of 30 top shares of the companies listed on Bombay Stock Exchange, and Nifty 50, top 50 stocks on National Stock Exchange. But then their movement affects the market. So how does they affect any company specific news? Yeah, those are listed on the stock exchange. If they come out with any good news, the market takes up. If comes out with bad news, the prices go down. Any industry related news, suppose something happens in the sugar industry, something happens in the communication industry. So industry as a whole, the index is affected, and it may go up and down depending on the positivity or negativity of the news. And something is economy related news, like we have so many news going now, Russia, Rus, and this Ukraine, and lot many countries, NATO companies getting countries trying to intervene into this. So there are lot many things which can relate, affect our companies. And what are the safe principles of the investment are? One should invest in the leaders, take big profits and small losses also, understand tax implications before getting into any transaction issue. One should be very careful that not in panicky or greedy situation they invest or come out of the investment. But in a long-term situation, to generate good profit, one should have the faith and patience. And somehow, if somebody gets into the weaker section, slowly get out of it and get into growth sectors. So, a line of caution to all of us is that one should take care of the safety of investment also, that avoid investing in lottery companies, avoid investing in chit funds, avoid investing in the credit cooperative societies, those who themselves call banks like Adarsh Credit, Sanjeevani Credit, Sahara Credit, PACL, or any kind of bitcoins, because the digital currency is not at all registered into the regulated in the country. So any scheme which ensures guaranteed income or unusual returns should be avoided. But yes, it is very important that we need to invest. So before getting into investment as a legal person or as a layman or as an investor, we should read the documents very carefully. What is written between the lines is the profession, our profession. Ask questions to understand the scheme, company, and the profitability or risk factors. Do sign the documents and keep a copy. So if the copy is there, we can get into the complaint or grievances redressal mode anytime. Modes of offering shares to the public is that FPO, that is fixed price offering, and through the book building process, that process is given by the SEBI and approval is given by the SEBI and offered on the stock exchange. What we need is the right of investor. Here comes our role as a legal professional also. We the investors are there to receive all benefits, material information declared by the investor, by the company. We have the right to get the prompt services from the company as transfers or transmissions, subdivision, consolidations, or equity holders having a right to subscribe to further issue of capital. Contact note from the brokers we need to have, and be careful while executing the power of attorney, but it gives lot of power to the broker. And we have the right to not to keep the funds and securities idle with the stockbroker. We have the right to regularly log in on our account, check the balances, and verify the demat statements. We have the right to get the messages sent by the exchanges, and we have the right to bring to the notice any discrepancies in our account or settlement. Regional investor service centers of BSE are there for lodging the complaints in all big cities and definitely in all capital cities of the state, where we have the obligations of as investors also, that we need to keep our KYC, that know your client details, documents provided, supported, and in case of change, updated with the broker also, updated with the stock exchange also, updated with the demat depository participant also. Any operational framework we need to understand before getting into any transactions. We have to pay the margins in time. We have the right to get the money when we sell the shares, but we have the obligation to give the money when we purchase the securities. All verified details of the trades we have the right to get, but then we need to update our mobile number, address, and email ID immediately on the broker and depository. Group websites of BSE are quite interesting. Just for instance, you can put a look at and get into the these details whenever you find some time. BSE IPF is there, Star MF is there, India ICC is there, India X is there, Marketplace Technology is there, Members Portal, and BSE Samman Portal. Right, secondary market. Yes, we are there deep into secondary market, which is we call stock market, and everyday transactions are taking place on the secondary market. And trading on BSE platform is the trading time pre-open session right at 9 o'clock. Trading sessions start at 9:15. There are groups made by the company, the SEBI, A group securities which are top notch, B that mid sector, T they are on the small case, and Z those who are risky. Type of orders, we can limit the market, we can give the market orders, margins, trades, price bands, circuits, and everything is well decided by SEBI. So all things are very open, and settlement is T+2. Like we do the transaction today, day after tomorrow, the money will come to your account. We are trying for T+1. That is, we can get into the settlement T+1 only. So this is all I have from my end as a resource person from BSE Investor Protection, and I greet you again on global this Money Week 2022. Any question if you have, probably you can ask me the questions also. Any questions you have? Then
Yes, Dr. Mukesh, thank you for delivering so finely the step-by-step all the ways how to be building us as citizens into the world of corporate and keeping in view the economics and the finance and whatever sectors that has to be, one has to be aware of.
thank you.
I think Professor Salvatore, sir, are you there? Salvatore, sir, are you there? So now your comments, your panelist, I have hold on for 1 hour.
Can you hear me?
Yes, sir, we can see you.
Okay,
And
so
hear you.
and you can see me properly?
Yes, sir. We can see you properly, sir.
Okay, thanks so much. Thanks so much. Just because the troubles are still on. Anyway, I wish to, before everything, it is my duty to once again thank
Ministry of Argentina is speaking.
maybe there is the, okay. I wish it is my duty to once again thank BHUPAL Nobles University for yet another opportunity for an academic meeting at its Faculty of Law. And once again, without repeating myself, this is very difficult. I wish to reiterate how stimulating it is to reflect on law with you and your alumni. This is a sign of a thriving and stimulating academic reality, and aimed at the progress of its scientific community, intended it as a whole, and its students, its lecturers, its professors, and the territory it represents. Of course, my due thanks go to Professor Singh and my gratitude for her tireless work as organizer, for the constant stimulus she provides to all of us, and for the quantity and quality of the scientific projects she enables us to develop for the benefit of all. I wish first of all to thank also for the for the link, for the concept that are going to link all these seminars, all these meeting concerning the liability, and that is the changing concept of liability and its variables. Why these? I believe that the changement is something that is part of the law, of the legal system. So it is part of ourselves to study what is going to change, what are the new, what are the difference with regard to the past, to the present, respecting the future. But the judgment has a rules in itself, so it is part of our concern to individuate what these rules are, and mostly to understand what is the element that are going to change, how we can detect a changement, and of course how we can detect something that, according to a great theoretical scientist that was the beloved Robert Nozick, what are the invariances in a concept or in a legal system. Uh, uh, My approach will essentially respond to an institutional logic of concepts, assuming that our need to elaborate the concept, to observe their physiognomy and changes always responds to two symmetrical processes that the jurist, the interpretation of law, carries out in his ordinary activity. First is the decomposition of each concept according to the multiplicity of its constituent elements. We are like children who have to dismantle, a toy to understand how it works. The second is the recomposition of it, starting from all these elements and observing their physiological evolutionary process. This may mean that disappearance of some of these elements, the modification of the legal meaning of others of these elements, the emergence of new elements that practice or the legislator directly or indirectly may have provided for to the interpreter as constituent elements of the concept, thus emerging, we can say, from nothing except a decision. Therefore, thanks to the level advancement of the studies of the audience here present, I think it will be possible to adopt this price and this approach with respect to some of the concepts that make up the very fast field of vehicle liability in the European and the Italian system in particular. It is very well known that this type of liability, due to the extent of its application, the dynamics that characterize it, it is one of the most important in the world of contemporary law of liability. This is demonstrated, first of all, by the number of cases and the vast amount of case law concerning it in every national legal system. In Italy, the main provision is Article 2054 of the Civil Code. Its heading is circulation of vehicles. Its text translated read as follows. The driver of a vehicle without rail is obliged to compensate for the damage caused to persons or property by the circulation of the vehicle. If he does not prove that he did everything possible to avoid the damage. In the case of a collision between vehicles, it shall be presumed, until proof to the contrary, that each of the drivers also contributed to the damage suffered by the individual vehicles. The owner of the vehicle, or in his stead, the usufructuary or the purchaser with the reservation of title, shall be jointly and severally liable with the driver, unless he proves that the vehicle was driven against his will. In any case, the persons mentioned in the preceding paragraphs shall be liable for damage caused by construction defects or lack of maintenance of the vehicle. Sorry, I hear an underground sound. It is done by me.
So we can all hear you very well. You're quite audible, nicely.
Yes, sir. We can hear you, sir.
I hear an underground sound. Maybe, is there any microphone on? Maybe.
Let me check if anybody has kept it. Mic.
Thanks so much. Thanks so much, Professor.
Okay.
Okay, thank you. Going back to the concept. Now, as can be seen, the regulation is entirely focused on the subjective element, and this is what I wish to focus today, as in terms of a concept, in terms of a changing, and in terms of the elements that constitute the subjective element. I mean the person whom the legal system holds liable for damages caused by the circulation of vehicle. Around the subjective element are constructed a series of dutiful conducts and the imputation technique that the regulation adopts and which the subject must assume if he is to be freed from liability. And according to this concept, we have the very clever punctualization of the title of this seminar, that is the so-called no-fault liability. More than no-fault liability, I will say no-fault imputation. Because as we can see from this kind of imputation, we have many way out. So liability is only the event in the case of which these ways out are not being took properly by the defendant. The third paragraph, that is a common paragraph, a common norm inside the European law system, as we have just read, sanctions the liability not only of the driver. Let's say the driver is the most common example of a car. The driver who causes the damage, but also jointly and severally the co-responsibility of the owner of the vehicle, or the usufructuary, or the purchaser with the reservation of title. The reservation of title in the European civil law system is the purchaser with installments. You know that this contractual scheme works in a very particular way. It immediately transfers the possession, okay, but it does not transfer the property, because the property will be transferred only after the payment of the last installment. So we have these three figures that, if we apparently see them from the perspective, the usual perspective, that normally assume one field, let's say property law, or another field, let's say liability, law of liability, are very few features in common. The proprietor, the usufructuary, the purchaser on installments. What do they have in common? We can see as a typical example the purchaser of a motor vehicle on installments, purchaser who will therefore only become the owner of with the payment of the last installment. Okay, what is the user? Why I say this? Because here we have the most restricted area according to a property law perspective that drives us to the common core of the concept that we must examine as an invariance in the changing of these concepts. What is this common core? It is the disposability of the good. Let's say the good as a, we can say a car, we can say a truck, whatever it is, the vehicle. The generic norm in European law talks about whatever can be driven without a rail. So it is excluded the train, it is excluded the tram, it is driven freely by the driver. That is the concept. Okay. The legal relationship that link the subjects to the object, let's say the car, is the disposability. How this disposability as a legal factual concept take the forms inside the many forms through which property law or property rights can be assigned is matter of examination. And it is the very hardcore of the changement of the concept. Because around the disposability of the subjects, beside the concept of vehicles, beside the concept of our subject of today, there is a large development of many contractual firms that today took place in common law and in European law, and I believe that we can say these worldwide, and that assign this kind of disposability even through different form of contract. I see, let's see, the first example I have in mind is the leasing, for example, okay? If we focus ourselves on the concept of disposability, how can we exclude, notwithstanding the norm, the leaser of a vehicle or the renter of a vehicle in a very common experience of the rent-a-car when we are on touring, where we are everywhere. Okay?
Nice to...
Yeah, doctor, please.
I just out of curiosity, who are the regulators for the capital market in your country?
Sorry?
Who are the regulators for capital market in your country?
In my country, European Union.
Yeah. Having the control over the stock exchange and the capital market.
No, it is a free market, doctor. There is no controller.
Okay. Thank you.
No, there is no institution. The institution that preside this control is outside. It is in the outsider circle. We have an institution that is called the CONSOB, but is nothing else that intervene in the matter of a free regulation of the fair functioning of the market.
Okay.
If we can say this is a control. Okay. After the So we have this kind of a common element as a legal in a legal relevance that can be assumed as an element of indication of imputation, not of liability, of imputation. And it is the element that can link the user who caused the damages, the driver, let's say, to other subjects that were not present and whom intentional element is not relevant, his will, is not relevant his fault, is not relevant nothing of the subjective, of the psychological element through which normally we proceed by imputation. But in that case, they are imputable because of their position with respect to the good, with respect to the vehicle, okay? Unless they prove that the vehicle was driven against their will. Let's say a theft of the vehicle by the driver who causes the damage, okay? In the hypothesis of a liability for the circulation of vehicle, to whom does liability extend other than, obviously, to the driver of the vehicle at the time of the harmful element or violation of the rules of an administrative nature? Let's see the fine for speeding. Let's see this microsystem from outside in order to focus another element of this changement. And this element is that we are not the normal current legislation in matter of liability sees the concurrence not only of the principle of reparation for damages or restitution, sees the presence of other kind of values that from outside the system push on the system in order that can be re-equilibrated in favor of the weaker subject. And the weaker subject everywhere is, of course, the subject that has been damaged by the event. So upon this system from outside, it is clear that the structure of these rules say to us that this is a system of warranty, a warranty for road accident and for the victims of a road accident, who can choose turn to several parties for their compensation. Thus, for the above-mentioned class of person to be liable, the damage must simply be caused by the circulation of the vehicle. It is irrelevant whether liability is established on the basis of a presumption or a concrete finding or fault. So, having regard the changing and evolving concept, what kind of liability is this? According to some, liability is based on fault. The fault of the external subject to the event, let's say the owner of the car, will be of a failure to exercise vigilance or careless handling of the vehicle. According to other interpreters, liability derives from, I repeat, when I say liability, I mean imputation, because liability is the last exit of the imputation. But at the moment of the event, surely the extension of imputation arrived to this kind of subject. They can be exonerated or not at the end. Okay, so liability in the sense of the system, it is not liability in the sense of the concrete condemn. But liability in these cases derives from the principle cuius commoda eius et incommoda. That is a Latin phrase, a Latin motto, that means that the one who has a property over something has also the incommoda, that is the troubles to manage the things that are under his property. So there is a liability for the interest satisfied on the basis of the different types of inherents mentioned above. And so we go back to the, the different figures of property law and property rights that describe this kind of inherence between the subject and the car. I repeat that this possibility is the common link that can connect property, usufructuator, the leaser, and the one who purchased it, like say, according to the law, and the one who purchased under installments. This kind of imputation by the majority of interpreters, even in Germany, let's say, is qualified for liability for the actions of others. Following this line also is admitted the compensability of moral damages without the need to establish an independent tort on the part of the civil liability. And it is very important because if we understand that there is a direct link, not is an indirect link between the subject that has been imputed, even in the case of his externality to the event, okay, the owner of the car and the son of the owner who is driving materially and causes the damage. In this case, there has been admitted the compensability of moral damages, not only for harmful and not only for the material damages, but also for moral ones. Few interpreters qualify this kind of a liability as typically linked to culpa in custodiendo, vel in vigilando. I mean, that is the same kind of fault that can be imputed to someone whose dog beat the passenger. Culpa in custodiendo, the fault in custody, or the fault in vigilance. This idea is confirmed by the fact that in addition to the civil code, the regulations on circulation vehicles, that is the legislative decree number 285 of 1992, the highway code, sanctioned that the violations by the driver of an administrative nature contained in the regulations, let's say the violation of a parking ban, in addition to the class of subjects mentioned above, are also extendable to the leasing user of the vehicle, the lessee. So we have I wish only to focus the last example and then to go to my conclusions, because I believe my time is expiring. We have had a very extended casuistic relevant formed on the subject of tachograph. I don't know if you have present what is a tachograph. The tachograph or chronotachograph is a tool that is mandatory for some working vehicles, like, for example, transportation trucks, buses. And this tool records information about driving time, speed, and distance. This is mandatory, and they are used to make sure drivers and employers follow the rules on driver's hours, on the speed. It is what is a registering of the activity, whatever happens in the truck, let's say. Well, in the in the first models, in order to adequately record the progress of the vehicle, the tachograph, the first times, had to be equipped with certain sheets of paper to receive the data recording. Now the operation changed because of the evolution, and now it is in digital form. Well, you know that in a constant case law, in this sense, in addition to the driver, let's say, of the truck, as always objectively, upon an objective nature of imputation, made the owner of the vehicle, let's say the owner of a transportation company or a bus company, liable upon the principle of no fault liability or strict liability in the event of the absence of tachograph on board on the vehicle, or if it does not work due to the failure to insert the sheet in the instrument, aiming subjective reasons put forward by the owner of the vehicle to be irrelevant for limiting liability. For example, that the omissive conduct was attributable exclusively to the driver, demonstrating that the sheets or the tachograph were regularly in his possession. So I wish to close in stressing this element, this possibility in its full form. If this possibility of the good, the car, the bus, the vehicle in itself, is the link that can connect many of the already existing property law, property rights situation, it is also, let's say, with a joke of words, the intellectual and scientific tools vehicle through which we can analyze the evolving concept of liability in this sense. This possibility is a premise for the exercise of power over the vehicle. If I am the owner, I can prohibit. If I am the owner, I can give guidelines. And therefore, to the possibility of prohibiting or authorizing its use. So it is an anticipation of responsibility upon the one who I am giving the vehicle. And this has often emerged in jurisprudence when it was a question of giving prominence to any property rights constituted by the owner with the third party, or when it was a question of giving prominence to temporary assignments of property. For custody reasons, let's say when I leave my car in the parking, when the damage is caused by a car park attendant and the extensions of liability towards the owner of the car park. We have not any proper relationship extended in time except that the custody. But in this case, the disposability, it is no more in the hand of the owner of the car, and it is in the hand of the owner, not only of the employee, but also of the owner of the parking. This is why they are liable. So if I can be useful for your attention today, I wish to focus these conclusions upon these two elements. The first one is that this possibility as the common core that can help us to see the changement, but let's say the invariance in this changement. And we can say that these are this is a field of study that is going always very, very quickly, the ability for vehicles. By the other side, let's say that this concept of this possibility, it is not only a static connection between the subject and the vehicle. This possibility is the total control over the vehicle even if given circumstances, even outside whatever the juridical position may be with me, with the subject and the vehicle itself. That is going from the ownership to the custody to the usufructuary position and many others. So thank you very much for your attention. I'm here for your question, possibly.
Thank you, sir, for enlightening us on very good subject. Thank you.
Sir,
Thanks
I
to
have
you.
a very short question to you.
Yeah.
Professor, like you talked about some default of vigilance. So do you think default of vigilance is somewhere also incurring the sense of disposability, or is it relating to some kind of, way of attracting insurance company that this they have to look after whether they need not to pay more and more money if it is into some kind of damage. See, means how the default of vigilance is actually working from the part of the corporation who is giving insurance, and then you're, as a owner, you're paying installment. So where this default of vigilance works?
Thanks for your question, Professor Singh. No, I believe that vigilance is essentially the kind of criterion that we try to find in order that we can justify why a subject who is somewhere else, it is imputable for liable for the damages caused by another kind of subject.
Yeah, that's what I'm saying.
So yes, but this is a I believe that this operates on a different level. That is the more technical level. What I wish to understand, if I correctly understand your question, it is how and where we have to drive these technical issues. Because the knobs are in themselves. The current ratio is surely the one of a more secure compensation for the subject, for the damaged subject. Okay, because in the case of a simple input fault compensation, I could find a truck driver was not any special patrimonial capability to compensate the damages as caused. Okay, so in these cases, there is not only the direct personal compensation that many of subject for the mandatory has to assume. Okay, direct. Like, let's say, in another field, a medicine man surely has an assurance. Okay, it is not for vehicle driving, except for many cases. But this is not only the direct as profession. Okay, the assurance is on the vehicle in itself. Okay, but the assurance on the vehicle itself is not depending always by the driver. The assurance on the vehicle itself depends by the disposability. If I must assume that there is to be paid for having not assured the vehicle, I must find who has the disposition of the car. And normally we find that it's registered as because cars are, for example, cars or bus or many others are registered. This kind of registered good. This registration is not constituent of property because only it's a declaration. It serves because of the priority in the exchange for the confirmation of exchange. So it is not a constitution type registration, but it is the record where I can find the one who has the disposability of the good. And the one who has the disposability of the vehicle is the one who is mandatory as to assume the insurance.
Okay.
whatever the technique, and I am not, I don't see the technique of imputation as something stable, because as you can see, the connection between the contractual position and the situation of disposability may vary. Leasing was not so common 40 years ago. Now it's very common. To rent a car for touring was not an habit 40 years ago. Now it is. Okay? But renting a car, yes, these are the changing elements of the concept. But what are the invariances of the concept? I will focus, according to this very short lecture, because we will need weeks and weeks to talk properly and extensively of this subject matter. I will say this possibility, and this possibility in the sense of the full control of the inherents in the vehicle. Thank you, Professor.
Thank you, sir. Dr. Kamal Singh ji, are you there on screen? Dr. Kamal Singh ji. Dr.
Yes, madam.
Kamal Singh.
Good evening.
Good evening, doctor. How are you?
Fine, sir. It was really wonderful deliberation from your side, and I really enjoyed it. And thank you very much for everyone who attended and give your views on this all acts and related to environment and other things. Really, ma'am, wonderful program. It was wonderful symposium. I'm really very happy to attend this program.
Sir, I request Dr. Kamal Singh ji, I request you to be there on all 7 days. At least at the end of the, you should be there on screen or invisible
Yes.
in the screen by 7:45. Because
Always.
Professor Salvatore can give only a half an hour to us. Today
I
he
was
has
there.
given more 10 minutes.
There and Dr. Mukesh sir and Salvatore sir, really from Buenos Aires, from Oxford University. Thank you so much, sir. I'm so happy to listen to you here.
Thanks to you, dear doctor. Thanks for being so patient with me.
So nice, so nice.
Thank you all.
So we should give a hand of applause to Dr.
Yes.
Mukesh Bansal, who kept us bound some way in your absence. And even, the first day it was, and so he has to be given a good applause for the day. Here's up.
Yeah, it is really wonderful.
Thank you, sir. See you, sir. Good night.
Good night, ma'am. Thank you so much.
Good night, Kiran. You did not show your face to say goodbye to Professor Salvatore. And even to
Good
Dr.
night,
Kamal.
good night, everybody, and thank you very much. See you
Good
tomorrow.
night.
Good night, everyone.
I'm stopping the recording.